Hello everyone, I'm Kushal Shrestha, student ID number NPS 241, and we are a group of 5 members presenting on the issues of contract law and corporation law through this presentation. For the part A, the contract law issue here that we will be discussing is the question number 3 on page 263, chosen by us and approved by Jonathan Temporal himself. The question is, does Jenny will have to abide by the exemption clause that travel services have included in the contract? In relation to this case issue, the rules that can be applied are as follows. First of all, Leistrange versus Graukov 1934 2 KV 394 that states that an individual who entered a contract via signature have to abide by all the terms mentioned in a contract, even that individual claims that the terms mentioned in the document has not been read by him. Second, Curtis versus Chemical Cleaning Company 1951 1 KV 805. The applicant would not be bound to the clause even the receipt was signed by her because a misinterpretation was made by the staff about the receipt from the applicant. Third, Oceana Sun versus Fay 1983 HCA 32. No prior notice. A notice must be provided beforehand or fine while the contract is formed. So about the application, I'll be handing this presentation over to Mr. Savin for the more application. Yeah, thank you.
I'm presenting the rest of the slides. I'm talking about the application part. In this case, a receipt was signed by Jenny on whom the clause was there. And the implementation of the case Leistrange versus Graukov states that an individual who has entered into a contract via signature have to abide by all the terms and the condition mentioned in the contract, even that the individual claims that the terms mentioned in the documentation has not been read by him. Jenny has to be abide by those clauses. Now, talking about the Curtis versus Chemical Cleaning Company case, it can be also implemented in Jenny's situation. In this case, as no notice were served to Jenny, the cases Oli versus Marlborough Court Limited and Parker versus South Eastern Railway suppose the argument because the court has denied the incorporation of exclusion clause with no notice being served to other contractual party. Now I'm talking about the conclusion part. In this case, Jenny will not have to abide by the exemption clause that the bus service had incorporated in contract, even the document was signed by her. Because in this case, as no such prior notice was served to her and served to Jenny, and her signature was taken via misinterpretation. And now the rest of the slide will continue by my friend Lakshmi.
This is me, Lakshmi Shrestha. Now I'm going to talk about the company law issue. The first issue is the problem that is to be addressed in this situation is whether Jacinta suggested to any specific rights regarding the company, and the sub-issue is whether any dictatorial duties in the section 181 were breached by the bill or not for acting an improper motive. And the next one issue is whether if Jacinta is capable of making claims that would result in actions being taken against the directors. Now I'm going to hand over next presentation to the Susan. Thank you.
Thanks, Lakshmi. Now I would like to give the presentation on rest of my topic. As we know, Lakshmi has already mentioned about the issue of the company law. Now we are moving towards the rules. There are 3 rules, and now explaining about the first rules. That is, directorial actions that fall against the proposition of benefiting a company that is making a profit cannot be taken into consideration as an act done in good faith or proper purpose as stated in the ASIC versus Haliter case. The next rule is Howard Smith versus Ampol. All ER 1126 can be taken as an example where it can stated by the court that if a said transaction did have two proposes, then the legitimacy of the act is cleared by checking the proposes that seems dominated. The last rule is under the S232, such shareholder can take legal actions by appealing to the court, and the court hence will pass law according to the S233 of the CA. Orders can range from simply purchasing shares from the persons who is affected to other specific orders. Thank you. Now I would like to hand over rest of my presentation to my friend Anupaka.
Susan Dundell for letting me to complete rest of the slide. Today I'm going to explain about the application of the company law issue. There are mainly three applications under the company law issue. The first one is any share of profits in dividend is not only specified by the organization. Either way, it is up to the behavior of the director that decides whether share of dividends can be given or not. The second application is in the case mentioned, Bill's action are solely for an agenda directing towards profit making. Agreed upon the every shareholder versus Ardena Cinemas Limited number 2, 1951, chapter 286 solidifies that the sole interest of an organization must be to safeguard the best interest of the owners or the shareholders of the company as a whole, and not just to the shareholders or the employees. Bill hasn't shown any such responsibility towards the shareholders. The last application of this issue is, hence, in the case in the hand, the sole reason that both Jacinta and the UBT are not best owed the right to hold shares in the company, in the sheer factor of the fear that Bill has of the martial situation threatening the company in same way or the other when in the near future they might have a divorce. Now I'm concluding the part. Such an adverse decision can only be made by a person who doesn't have a proper purpose and has hence violated the rules and regulations that are mentioned in the laws and section mentioned and situation studied above. Jacinta has the right to make any derivation action or cases in the necessary action Bill, for he has clearly breached the laws stated in S181. Thank you. This is the completion of our slide. Thanks everyone for cooperating us. Thank you.